Well, it's trial records have not arrived. We were supposed to file a small compilation, and also a report was to be submitted by the superintendent of jail. Well, it was not received.
Yes, fine. Now, you are the conducting advocate there. You are the trial court.
No, my lord, I was not the conducting counsel there.
You have been appointed by the legal aid.
No, my lord. Well, they have come to me. My lord. It's more like a pro bono matter, my lord. Lordship, they give me a week's
No,
time.
but why LDC and others are not there? You have a system why they are not being appointed. Why it is legal defense counsel are there?
They are there, my lords. They are there. There are a
So
number
why
of
they are not
legal
being
aid counsels.
appointed? That's the reason I want to know.
Okay.
Because appointed by them, by the
By the family, my lord. The family somehow approached me.
it's meant for them only. Anyone for the victim is appearing?
Sorry,
No,
Lordship.
no.
No, but the victim is not a necessary party.
In
my
the
lord.
appellate,
Lordship, Jagjit Singh has made it clear. Only for the bail matters, victim has to be heard. Not
But
in
for suspension of sentence, if an application is filed, and suppose because that will amount to also enlarging the
kind of bail.
enlarging the victim, the accused on bail. So amounts to suspension when you suspend the sentence and release the accused on bail, will it not be required? What do you say?
Definitely.
No, my lord. As far as bail is concerned, my lord, during
No. Once it's a question of suspension of sentence, so we will be enlarged on bail on certain conditions. So it amounts to ultimately is granting a bail to you.
bail,
Exactly.
absolutely,
So if the victim has a right
my lords.
to oppose the prayer of bail,
Lordship.
whether it is anticipatory or main bail, whatever is the case, why not for the purpose of suspension of sentence? Where the
Lordship is correct. Yes.
Impliedly, my lord, yes.
Look into that.
We never,
unless the law says something contrary to it. But what the judgments say on this?
My lord, as far as my plea of suspension of sentence is concerned, my lord, here what has happened, my lord, I was
No, that's fine. But
Under-
I just want to know that whether the victim is required to be heard or not.
my lord, technically, my lord, as far as my lord, I'll have to do some research because Lawrence Senior will also help me. When it comes to bail applications, my lord, of course, yes. But suspension of sentence, my lord, I have not come across any such situation where my lord the victim has been hurt.
Because ultimately resulting in granting a bail.
My lord.
Lordship, the only difference is this: unlike bail and suspension of sentence, in bail, prima facie, the issue of evidence is not involved.
But here the evidence is at the
Yes.
final stage.
So this first,
So what do you say about the suspension of sentence?
suspension, Your Lordship, last date we made a submission because a bit of merit has to be touched.
Go by the evidence on the basis of the trial court has delivered the judgment. The clinical examination, nothing is shown, nothing is revealed, excepting the sole testimony of the victim.
Lordship. It's pending before it was listed yesterday, but it couldn't be taken up, my lord. So
So we keep it in the next year
yes,
in view of the fact that the issues involved herein
yes,
are also the issues involved herein, and that the Honorable Supreme Court is insisting over the matter which involve some of the issues
yes, my lord.
involved in this.
Asking for time. Asking for time. Time.
Maybe this is Lordship. Lordship, in terms of the last order, Lordship, we have taken steps. So before the Honorable Supreme Court. So Lordship, I'm praying if this matter can come up after 4 weeks, Lordship.
On the prayer of the learned counsel for the petitioner, is a public investigation.
The collected matter was disposed of last week, my lord.
Yes.
And I had taken time. The only difference, my lord, in the matter disposed of, they were junior lab technicians. They are appointed in the pay scale of 4,500. And the present respondents are, my lord, they joined as junior lab technician, my lord. Subsequently, they have been promoted as senior lab technician within the department. So at short time, they are also seeking same relief, my lord, that from 1/1/96 or the date of joining, they should be given the pay scale of 5,000 rupees. My lord, I sought time on the last occasion only to figure out, because subsequently they have been promoted, my lord, and the promotion is within the same pay band, my lord. We will also recollect the other matters. Pay scale of 5,000, 5,500, and 6,000 were merged, my lord, in the sixth pay commission. So, my lord, what I would pray, my lord, the matter may be disposed of, leaving it open-ended, my lord. The subsequent pay scales, fixation of subsequent pay scales, will be done by the department in accordance with law, my lord.
Where is the previous order? Do you have the
My lord,
previous?
I have got.
So, according to you, this what observation you want us to make?
And only thing, my lord, if you will also kindly see is the improvement paragraph, paragraph 14, my lord, at page 107.
As regards the averment of the applicants,
Paragraph 14 of the impugn order, my lord. page 107.
Yes, yes. What will be the pay band and other things?
Yes, my lord. Pay band, because that point of time, fifth pay commission was applicable, my lord, 4,500, and it was upgraded to 5,000 rupees. Now, subsequently, because of sixth and seventh pay commission, the pay scales have changed. My lord. That's what I could not figure out exactly, my lord.
No, you see that paragraph 40
Yes, my lord.
has to be implemented on the basis of whatever the pay revision or pay arbitration is there.
Yes.
So whatever was there was the then what was existing at that point of time.
Yes, yes, my lord.
So pay revision or grade pay, whatever the thing is there. In the meantime,
So, my lord, the first direction, if also kindly says, accordingly, we hold that the applicants are entitled to the benefits of such upgraded pay scale of rupees 5,000 to 8,000, or in the revised pay band of rupees so and so with grade pay of 4,200 with effect from the dates of their joining as GLTs in agreements. So this my lord, we cannot really dispute this portion, my lord, because that has been given to the other GLTs who are still GLTs.
then
But the subsequent direction, my lord, consequently, as the applicant number one is subsequently appointed as SLT from so and so, you will be entitled to grade pay of 4,600 with effect from 1/1/2006. And in case of the other applicants, they are entitled to granted pay scale of grade pay of rupees 4,600 from the dates of either promotion as SLTs or financial upgradation. My lord, these subsequent things, what I'm praying, my lord, we will also leave it open-ended, my lord. We will implement it, we will calculate and all those things, my lord, in accordance with law.
no, but what do you want us to say? That's what I'm trying to find out. We simply affirm the order. That ends the matter. Whatever is there is you apply the. You will be entitled to grade pay of 4,800 towards next financial upgradation under the MSCP scheme. So, you implement this order, whatever the upgradations, why you want us to record anything on this?
But what exactly I was praying? Initial claim was, my lord, when they were junior lab technician, my lord.
You see, you are implementing this order.
That part we are implementing. That is the direction in the other matter also, my lord.
So you implement this.
So once we implement that, my lord, it will have consequential effects, my lord, on their MSCP, on their pay fixation.
Whatever is there, that is not the subject matter here.
But the learned tribunal is directed that way.
Yes. So which one?
That's the second component, my lord, of the order.
All the applicants will be entitled to all the constitutional benefits, including payment of arrears.
Yes, my lord.
The response is directed to carry out the exercise as directed. So, what do you want exactly? We are not very clear.
My lord, what I wanted, because this part, my lord, whether their next MSCP will be to 4,600 or to 4,800. Because in
That
the
will
mean,
take a call. That will take a call. We are
yes, my
only
lord,
simply
that's
affirming
what-
this
that
order.
liberty, my lord. But we should have the liberty to examine that aspect, my lord. Because they're gaining promotion also, my lord, and they are also asking
See,
for
if we are getting promotion, they will not be.
not be entitled to MSCP. But that's the only thing, my lord.
Why you want us to say anything on this? If you have power, you do it.
My lord.
See, if by reason of say revision,
Yes, my lord.
they are out of the purview of MSCP or not, and they cannot claim further MSCP, that is a separate thing altogether.
My lord, because they have been in the meantime promoted also. They have become senior.
So if they are promoted by that time, so up to the stage when they are entitled to such benefit, they will get it,
Yes, my lord.
and after promotion they may not get it.
Yes, my lord.
So that will be carrying out this order according to your own interpretation. So
Right.
why you want us to say something which may lead to some
Yes,
confusion?
my lord. That is because there are several petitioners. Was it a case of one
You
petitioner?
calculate it. If they have anything to say, if in a future proceeding, if they say that this order is not implemented in the true sense, if that comes up, then we'll decide. Otherwise, there is no question. Take down. We have heard the learned Deputy Solicitor General. It is submitted that by reason of the passage of time,
Yes,
since the order was passed by the tribunal, the respondents have been promoted.
no, madam, they were promoted before that.
Prior to that. Prior to that.
Prior to that, that's why there are two separate cases, madam.
The
One is the
respondents,
GLTS.
the respondents were promoted prior thereto, and their entitlement has to be calculated taking into consideration their date of promotion
Yes.
in order to avail the MSCP guideline, in order to avail the benefits under MSCP. Correct?
Yes.
We are not entering into the said issue as we are only required to decide the legality of the order passed by the tribunal. The manner and mode of execution of the said order is not presently before us. Full stop. In view of the fact that similar Yes. For the list.
Item number 1.
Please, Lordship.
Yes.
We will Lordship in urgency, Lordship, this matters, Lordship. And pray that matter may fix it on Monday, Lordship. Senior counsel is indisposed, Lordship. Kindly, Lordship, have
But the order is in your favor.
my Lord.
The order is in your favor, and the union has passed already an order. The order is in your favor.
Lordship, I'm being led by the senior counsel, Lordship, so I'm not well versed
But-
with the matter.
You have the writ was allowed, and then you preferred an appeal against that order.
Lordship, actually, I apologize, Lordship, I'm not well versed with the matter, Lordship, so.
Focus had always been issued.
Appearing for respondent number 2.
Oh, he's
I
appealing
too,
for?
my colleague, my instruction counsel.
Huh?
He is assisting me.
He's assisting you?
Yes, yes.
Oh, that's okay.
He can file a fresh writ petition if he is agreed with. We have given a show cause notice.
Exactly, but this, you have won the matter before the trial. You are not aware of this matter.
No, Lordship.
Where is Miss K. De Cruz?
She's,
She was a counsel appearing,
Lordship, she's assisting counsel, Lordship. She's the assisting
but
counsel.
she should have been here
She's
instead of having a stranger to the matter being here in court.
apologize, Lordship. Kindly fix it on
She should
Monday,
be
Lordship.
here. Otherwise, we cannot take note of your presence.
Lordship.
With regard to arbitration clause, Lordship has held in the Calcutta High Court with Lordship Justice Kapoor. But judgment is very clear, Lordship has taken down. When arbitration clause is there, party has scored.
That judgment, that's why I referred to in the other operation. No, but writ is allowed now.
Writ is
So
allowed.
that is now become not relevant.
He is challenging again that part. Arbitration clause observation. There is single bench make observation with regard to arbitration. So he is challenging that part.
No, but here, this, his writ was, he said that he was not heard.
Yes. So we make a concession that we will give a fresh show cause notice, give him adequate
Yes,
opportunity.
so
We
I
have
don't
given
know.
him, he did not respond it. So we pass a final order. So he can file a fresh writ if he has agreements with that.
Don't know. Whether the prayer for adjournment is made.
Please, my lord. Lordship, on the last occasion, Mr. Gautam has apprised his court that the applicant wishes to engage a senior counsel. But, my lord, we have received instructions that no forthcoming answers.
Sorry?
My lord, we have been informed that the applicant no longer wishes to appoint a senior counsel. My lord. So the matter will be argued by Mr. Gautam. The lordship is praying for accommodation for today, my lord.
No further, sorry. Last time, it cannot go on like this. Please argue. We are not going to adjourn this matter.
My lord, let it pass over for just for the next call, my lord. I'll just inform
Well,
Mr.
pass it
Gautam.
over
My lord.
once. Yes.
All right.
Number 2.
Yes.
My lord, this is CRP, my lord, civil revision petition against the order of the appellate court, my lord. My lord, what happened here, my lord? We filed a suit before the London court at Circuit Court, Fulbury, my lord. And in that suit, with regard to the disputed property, my lord, for a declaration of right, title, and interest. And on that suit, we filed a miscase also. In that miscase, the status quo order was issued, passed, my lord, by the learned trial court. And against that order, the respondent had filed appeal, my
You
lord.
are the plaintiff.
I'm the plaintiff, my lord. And
Just show me that. Just show me that how the finding of the additional deputy commissioner
Yes,
is
ma'am.
wrong. Come to the paragraph 31 of the judgment.
yes, ma'am.
The finding is that in bold, if you see paragraph 31, have you got it?
My lord, yes, my lord.
Please read it, paragraph 31.
Yes, my lord. Thus, it is seen that the learned trial court has not taken into account the relevant facts and has not given its finding as per the settled principle of law while considering the grant of injunction. The respondent plaintiff has alleged about 4 biga 0 kata 11 lesa being covered by Patta number 514, dag number 740, and the alleged schedule is not supported by any document. Nowhere in the plaint there in any whisper or statement as to how and in what manner the respondent plaintiff become the legal owner of the suit plot of land covered by Patta number 514, tag number 740 as mentioned in the schedule of the plaint. The annexure 8 of the plaint, that is the land Patta number 514, does not contain any land under tag number 740, but that tag number 936, 848, 1032 and 739. The possession of the respondent plaintiff is also in question. Thus, the respondent plaintiff has failed to establish prima facie case.
So how
My
it is,
lord,
if in your
that is-
plaint, you show me that you have traced your title to this particular plot.
Yes, my lord.
So
My lord.
you have to show that you became the legal owner of the plot unless you claim it by way of an adverse possession.
My lord. My
So
lord.
you have to show it. Where is that finding?
Yes, my lord.
Where
My
is
lord,
that pleading?
My lord, in this suit, my lord, there is a bona fide mistake with regard to the tag number, my lord. But the patta we have annexed, my
No,
lord.
no. Dag number, bona fide mistake, we understand.
Yes, my lord.
But tracing of title, you have to say that this is how I trace the title.
Yes, my lord.
You come to paragraph 24 of the judgment.
Yes, my lord.
Come. Read that paragraph 24.
Yes, my lord. Paragraph 24. Yes, my lord. Heard the submission of both parties and peruse the appeal and also relevant documents annexed herein. On, on perusal of the plaint of the respondent, it is seen that he has claimed the suit property falls under patta number 514, Mausa number so-and-so, lot number so-and-so, and dag number 740, and whereas annexure 8 of the plaint, which plaintiff claims to be the patta of the suit property. There is no reflection of dag number 740. Instead, there are 4 dag numbers, that is 936, 848, 1032 and 739. There is also an admission from the appellant that only some portion of the suit property has been sold to the respondent plaintiff, but not the entire area. However, the respondent plaintiff have claimed that an area under dag number 740, which is nowhere reflected nor substantiated in the document of the plaintiff.
Respondents.
Yes, my lord, respondents, my lord. Yes, my lord. It has also been brought to the notice of this court that the respondent, on the basis of the status quo order, have managed to obtain an order dated 28/5/2024 from the learned trial court restraining the appellant from their land with a wrong DAG number 740, which was never in patta of the appellant nor in the patta of the respondent. Even the respondent has admitted that DAG number 740 as mentioned in the plan has been wrongly entered. Therefore, it is seen that an incorrect DAG number has been shown in the pleadings of the respondent plaintiff, which is in stark contrast of the documents annexed by the respondent plaintiff. When an incorrect area has been pleaded, which has even been admitted by the respondent plaintiff, then a restraining order over such land is not sustainable.
Correct.
Yes, my lord. My
Pause
lord,
here for a moment.
my lord. Yes, my lord.
If you have given a wrong DAG number or wrong patta number,
Yes, my lord.
first of all, you have to file an application for amendment of the plaint.
My lord, which is why, my lord, the in pleadings, my lord, we have annexed the in the plain,
Doesn't
my
matter.
lord. Yes, my lord.
If there is an incorrect description, first you have to file an application for amendment
But
of the
already moved, my lord. The amendment application was heard and the matter was pending for orders, my lord, on 17 November.
So this we are not interfering with the order.
My lord,
So this
I-
order will on the basis of the facts.
My lord.
So on the basis of the amendment, if you are able to establish your right.
My lord, yes, my lord.
So this
My lord,
perfect.
I humbly submit, my lord. Kindly grant us some time. My lord,
No, this order is perfect.
my lord,
This order is perfect.
my senior is to argue this matter. Kindly, my lord, the
remains.
matter
Nothing remains.
is
Stay
pending,
down.
my lord.
Nothing remains.
My lord, kindly, my lord, I humbly.
No, your
beg
application
request.
for amendment is pending. That's not.
Yes, my lord, we have moved an application. Application was heard, my
amendment
lord.
is pending. So the amendment, if the amendment is allowed, you may move for. You may file an application for status quo.
Yes, my lord, that
That's
is.
why, that is precisely what I am saying.
Yes, my lord.
Take
Yes,
down.
my lord.
The learned counsel for the app. Yes. Yes, give us the papers. Yes.
Me, please, Lordship.
Yes, yes.
No, this is the revision against the order dated 18/4/2024, passed by the executing court, where a direction has been given to the applicant to remove all the goods and articles from the suit premises.
Yes.
No, my lords, here, in the year 2003, my lord, a suit has been instituted by the respondent for eviction,
Yes.
and by, my lord, and judgment and decree dated 29/11/2012, the suit has been decreed in favor of the respondent. No, my lord, against the said decree, an appeal, my lord, has been preferred. When, my lord, this honorable court has upheld the judgment and decree passed by the trial court on 23/2017. When, my lord, in the same year, my lord, in 23/8/2017, an execution application has been filed by the respondent for executing the said decree. Now, lordships kindly have the decree on page 14.
Either you remove the articles or will direct the bailiff with the help of the police to throw them out after a proper inventory is made.
No, my lord, our only ground is that since the decree with regards to the eviction has already been satisfied, no, my lord, subsequent order for removal.
It's not a question of subsequent removal. What happened? The bailiff has kept one room under lock and key where your things are lying.
Lordship.
So delivery of possession was there, but your goods are lying in a particular room. So the bailiff has sealed it. So to that effect, it has not been completely discharged. Bailiff has been discharged.
No, my lord, as per submission, yes, we said that
No,
the
it's not
execution
been
part.
discharged.
No, bailiff was not discharged. Because the executive court has not recorded, the decree stands satisfied and hence bailiff discharged. Show us the order where it is. And if your materials are there, if the bailiff is still there, if your materials are there, then unless the materials are not removed by you, then he cannot enjoy that particular room. And he will be entitled to mean profits for that.
My lord, it's not just one room, the entire property. It's been sealed by the bailiff. We are in symbolic possession, so to say.
We'll give you 1 month's time. If you do not do it, with the help of police, they will take possession. Your things will be thrown out of the property. Stay down.